From 18th of February this year, lots of changes to trade unions and to the rules about industrial action are coming into effect. These are going to include changes to the rules about picketing, enhancing protections for those who are taking part in industrial action, and simplifying the ballot process. In addition, new union members will automatically be opted in to contributing to the political fund of the union unless they opt out. And this is just the start of the biggest shake-up of trade union rights in years. From April this year, the qualifying period for taking paternity leave following birth and adoption will be removed. This will allow employees to take paternity leave from the start of their employment. And the Employment Rights Act 2025 also gives more flexibility over when the leave can be taken, as it will be possible to take it after shared parental leave. The Act also removes the qualifying period previously required for parental leave. That's the 4 weeks unpaid leave that parents can take each year up to a maximum of 18 weeks per child. If you're an employer who is planning on cutting 20 or more jobs within a 90-day period, you should be aware that from April this year, the penalty for failing to comply with your information and consultation obligations will double. At present, the protective award is 90 days gross pay per affected employee, but from April, this will be 180 days. April sees the launch of the Fair Work Agency. This has been set up under the Employment Rights Act 2025 in order to bring the enforcement powers of a fairly disparate group of regulators under one roof. It also has enhanced powers of inspection and can proactively bring claims on behalf of individuals or support claims that are already underway. From April this year, statutory sick pay will become available to employees from day one of that person's illness. In other words, the current 3-day waiting period has been removed, and the lower earnings limit to qualify for payment has also been abolished, which means that those currently earning less than £125 a week will be entitled to 80% of their pay. Employers will need to think about updating their payroll systems and policies in order to be ready for this. From the 6th of April this year, if someone tells their employer about an incident of sexual harassment, this will qualify as a protected disclosure under whistleblowing law. It's fairly unlikely that this will actually make much difference in reality, because workers will already be protected from victimisation under the Equality Act, and they could potentially have argued that the disclosure was already a protected disclosure under existing law, but it does remove any doubt. This means that if someone is dismissed for raising a concern, they could bring a claim for something called interim relief, and this entitles them to continue to be paid during the period up to the tribunal hearing. In any event though, employers should also be aware of other bigger changes to the law on harassment that are going to be taking effect later this year, including the introduction of third-party harassment. For more details, please head to our website mishcon.com and look for the Employment Rights Act Hub. There you'll see more information regarding the content of the Act, when different parts of the Act are coming into force, and what still needs to be decided. You'll also be able to download guides as to what employers should be doing to prepare for the changes and what training we have available for your managers and HR teams.